LIANZA presents 5 minutes on the Privacy Act 1993. The Privacy Act 1993 aims to promote and protect individual privacy in relation to personal information about individuals that is held by organisations or agencies. What is privacy? The legislation in New Zealand reflects the common meaning many of us identify as privacy, that is, an individual's ability to protect information about themselves. Despite the right to privacy that many of us think is important, there is also the need to balance social interest or public welfare. There are situations that may call for a lessening of an individual's right to privacy, such as in the prevention of crime or to ensure safety. If you have ever read George Orwell's 1984, the idea of having regulation over what the government can and cannot do is very appealing. To retain our rights as citizens, we feel the need to protect our privacy. What does the Privacy Act do? The Privacy Act sets out 12 broad principles regarding information privacy. This is a very brief summary of what each individual principle says. Principle 1. The first principle sets out the foundational rule that the personal information shall not be collected by an agency unless it is for a necessary purpose connected with a function or activity of the agency. Principles 2 to 4. The information must be collected directly from the individual, unless it fits under an exception described in the Act. Individuals should be informed of the collection, and it must be done in a way that is fair and lawful. Principle 5 sets out how we should store personal information so it is protected against loss or disclosure. Principle 6. This principle describes how an individual is entitled to access information that is held about them. Principle 7. Individuals are entitled to correct the information about themselves that may be incorrect or not up to date. Principles 8 to 11. These principles all describe how personal information should be used and disclosed. Personal information must be correct before being used. It should not be kept for longer than necessary. Information must be used for the purpose for which it was collected, and information must not be disclosed to a third party. Principle 12 applies to the use of unique identifiers in relation to an individual. What do organisations need to think about? Purpose. What is the purpose of collecting the personal information? Collection. How will you collect the personal information? Use. Is the way you use the information and the way you store the information appropriate? Disposal. Is the way you dispose of the information appropriate? Particular things to think about in a library. The membership sign-up process. Think about how the personal information of library members is collected, used, stored, and disposed of. If you use CCTV in your library, think about how the images of people being captured are being stored and used. Your website. It may be useful to have a privacy notice on your website explaining how your library collects and uses personal information. The book chapter entitled Libraries and Privacy from the book Engaging Privacy and Information Technology in a Digital Age provides a useful description of the role libraries play in protecting privacy of individuals. Although not directly relatable to our New Zealand legislation, it still provides a good overview of the main privacy principles in relation to libraries and technology. To see the Act itself, visit the website of the Privacy Commissioner, www.privacy.org.nz.